Roughly a year ago, you found the system of school finance in this state unconstitutional for a variety of reasons. We feel that after the evidence in the last 3 weeks presented, the evidence is compelling that the system remains unconstitutional for those same reasons. The actions of the 83rd Legislature as it pertains to funding. First, it's important, I believe, to focus on what was not done. State statute requires that the state make studies to determine what is the cost of the programs they mandate. What does it cost to create college and career-ready graduates? State law mandates that the weights be studied to determine that when you are making adjustments for comp ed kids, English language learner kids, special education kids, that type of population, that you adjust for it and adjust for it appropriately. The legislature could have performed such studies and could have adopted by statute a basic allotment that provides for the real cost of creating college and career-ready graduates. The legislature could have done the studies to determine what the real cost and what are the appropriate weights, but it did not. All the legislature did was appropriate money into the system, and unfortunately it did not even appropriate as much money as it had stripped from the system the biennium before. And the appropriation on its face is temporary and expires in 2 years. And we will be right back to where we were at the time we tried this case before you a year ago with the identical facts, because there has been absolutely no change by statute to the system. The funding gaps that you heard evidence about a year ago and you heard evidence about in this trial remain unconstitutionally large. Whether you look at those funding gaps based on a traditional average, as we have advocated, or whether you look at them on a weighted average as the state advocates, in either event, we're dealing with gaps that are beyond the pale of what the Constitution should allow for. Exhibit 11461 of the state, I think, made the point for us. Using their own weighted average, when you compared the wealthiest 10% of districts that have approximately 140,000 kids attending those schools with the 25% of the poorest districts that had approximately 800,000 kids attending their schools, what you saw from the state's exhibit was that the poor districts taxed at 9 cents higher tax rate and yet received, using the weighted average, which we think understates the problem, but received over $1,000 less than their wealthier counterparts taxing at a 9 cent lower tax rate. And as the court knows from the testimony, that translates into approximately $30,000 less per classroom. $30,000 less per classroom, and that's the state's evidence. The evidence that we presented shows classroom gaps of $70,000, $80,000, even in excess of $100,000. And the reality is that kind of money, $30,000 advantage that the wealthy have over the less advantaged, makes a real difference in the classroom. It provides for additional aides, it provides for higher teacher salaries, it provides for better equipment, all of the things that go into providing a quality education. Exhibits from the state in the examination of Dr. Dawn Fisher, I also think, tell a compelling story. The state's data on exhibits 11440 and 11447 were the spreadsheets that Dr. Fisher testified to extensively on cross-examination pertaining to what districts could raise at $1.04 and what districts could raise at $1.17. And as the court will recall, we ran her through those in some degree of detail. In a system that allows for a crystal ball in the exact same year with the exact same requirements on school districts to create college and career-ready graduates. Taxing at $1.04, a Cristoval raises $4,500, and at the same year, at the exact same tax rate, a Westbrook raises $14,000. Right at a $10,000 difference per WADA at the exact same tax rate on two different districts in this system, both of which are under the exact same rules and regulation and obligations. That's what this system provides for, and that's what Dawn Fisher said was just a product of the system. Now, the other thing that I think was striking is if you get away from the issue of weights and whose weighting methodology is accurate and just say, let's see what's really happening on the ground and compare districts side by side in the same county. And as you will recall, I took her through a extremely quick, but it's all in the record, and I know the court saw the slides of district by district in counties throughout this state, and I think she got confused, to be honest with you. She was all of a sudden saw these magnitude of these gaps. How can this be? How can we have a $7,000 difference? How can we have a $5,000 difference between two districts in the exact same county, taxing at the exact same tax rate? And I think she thought we were looking at ADA numbers that had not been adjusted for district characteristics, student characteristics, all the things that the WADA adjusts for. Because as the court will recall from the stand, she said, well, these are different districts, and they have different district characteristics, and that's not been taken into consideration. But it had been. That's what WADA does. Now, we, of course, I think all the plaintiffs believe that the weights understate the cost, are out of date, haven't been looked at in decades, and believe that's a problem, a huge problem in the system. But the concept of having weights, we think, is perfectly appropriate. And I think Dr. Fisher got confused when she realized how in the world in Webb County can you have two districts side by side, both taxing at the exact same tax rate, and yet one is getting $7,000 more per WADA than the other. How can you have that in East Texas? How can you have that in West Texas? Right here in Travis County, how can you have a situation where Eanes and Pflugerville taxing at the identical tax rate, Eanes ends up with $25,000 more per classroom than Pflugerville? That's what this system allows, and it's just a product of this system. It's nothing that the Eanes district is doing. It's nothing that the Pflugerville district is doing. It's just built into the system. That kind of inequity is what has been in the system for way too long, and even after the actions of the 83rd legislature, continues to be in the system. Now I want to turn my attention to a slightly different focus, which is the provision of a general diffusion of knowledge and the adequacy issue. A year ago, there were 3 experts who testified as to what they believed to be the cost to meet the current state standards and provide a general diffusion of knowledge. You had Dr. Baker, who took the pronouncement of the Supreme Court in Edgewood 4 that it cost $3,500 back in the 90s, I believe, and extrapolated that forward and said that was $65.76 per WADA in today's dollars. You had Mr. Moak, who did his analysis and said the cost of meeting the state standards was $65.62 in today's dollars. And actually, these were 2012 dollars. And then you had Drs. Pikus and Dr. Odden, who did a study and said the cost to meet the state standards was $6,176. Now, I think it's a cruel irony that the state has attacked each of those studies in every way they possibly could and said, this is wrong, this is wrong, this is wrong, while at the same time they have continually steadfastly refused to follow the state law and do the studies that they themselves are mandated to do. Nevertheless, I, in the cross of Dr. Fisher, focused on the lowest of those numbers, the 6176, knowing full well that if a district could not raise at least $6,176 per WADA, it had no chance and it was impossible to raise anything above that. And the sad truth is that upon the examination of Dr. Fisher, it was determined that there are only 124 districts in this state taxing at $1.04 that can even raise $6,176. And those 124 districts educate 144,000 kids. And those are 144,000 lucky kids. All the other districts in this state cannot get there, taxing at $1.04. And they educate 4.6 million kids who can't get there, who have no chance to get there. Well, you say, or I might say, they can go to $1.17. So what's the big deal? Well, the big deal is that I do not believe that you can put in the hands of the voters the ability to determine if their kids or the kids residing in their districts get a constitutionally adequate education or not. And you cannot tax above $1.04 without voter approval. But the saddest of the stories is, even if you went to $1.17, there are only 259 districts in this state of 1,020 districts that can even get to 6176 taxing at $1.17. That's the testimony of the state's Chief School Funding Officer, Dr. Lisa Dawn Fisher. Second, I asked Dr. Dawn Fisher, using the weighted average, to determine what was the weighted average per WADA for the state as a whole in 2014 as we sit here today. What is being spent on a weighted basis on kids across the state on average? And she did the calculation. We helped her do the calculation. It's on her spreadsheet, and it was $5,706 per WADA is what's being spent right now on average. We then took Dr. Dawn Fisher through the same analysis and, sadly but true, determined that taxing at $1.04, there are only 257 districts that can even raise the average today. Those 257 districts educate 923,980 kids. The districts that cannot get there educate 3.6 million kids. These can't even get to the average of 5706. Yet this is what is built into this system. Educating our kids, educating all of the kids in Texas, not just those kids that are fortunate enough to reside in property wealthy districts, but all Texans, is critically important to this state and to this state's future. I know the court will recall the testimony of Dr. Steve Murdoch, the former demographer for the state, now a professor at Rice University, when he walked the court through the changing face of Texas, the changing demographics of Texas, and made, I believe, a compelling argument that we are seeing in our public schools more and more kids of economically disadvantaged backgrounds. We're seeing more and more of our kids who are English language learners, and they're the ones who are hurting most under this system. The evidence is compelling that that population is the one who needs the most and yet is getting the least. We also have heard, through Mr. Diamond's presentation, the testimony of Bill Hammond of the Texas Association of Business, and how important it is to the business community that we graduate college and career-ready graduates, and that we have to have high school graduates who can meet the jobs of the future, and how that's not happening today. And you heard that ad nauseum a year ago from superintendent after superintendent after superintendent saying we are unable to get the job done. We want to get the job done. We have the will to get the job done. We have the skills to get the job done, but we don't have the resources to get the job done. And what is frightening and what should scare everybody to death is the STAR results, the STAR test results. Anybody who looks at those results with an objective eye has to say this public school system in Texas, as hard as it's trying, is failing, and it's not getting the job done. The Supreme Court was clear, exceedingly clear, when it said it would be arbitrary to set mandates and goals and expectations of your school districts and then not provide to those school districts the resources necessary to get the job done. And that is exactly the system we're operating under right now. We, the ISDs, and I believe you're going to hear the same thing or something similar from the charter plaintiffs, but those involved in public education today, those people who love the kids, who are striving to provide an education that is desperately needed for the kids, you have heard from them one after another, after another, after another, that we simply don't have the resources. This system does not provide the resources. And yes, I represent poor districts. And yes, Calhoun County represents the more wealthy group of districts. But we're all in the same boat when we say we don't have sufficient resources. They may be closer to having sufficient resources than my clients are. My clients are at the bottom of the heap here, and we've got a long ways to go before we have adequate resources. But as a whole, this system is failing virtually everybody. The legislature, for whatever reason, has faced this issue time and time again. And by I say this issue, I mean the unconstitutionality of the system. And they have put a Band-Aid on a Band-Aid on a Band-Aid. We have a constitutionally and fundamentally broken system. And it's time that that be repaired, and be repaired on a non-Band-Aid approach. We believe the evidence that we have presented to Your Honor is compelling, that the system remains constitutionally infirm, and we urge you to so rule. Thank you, Your Honor.